Welcome back to Canadian Justice, where we're discussing trains, planes, and labor strikes, and the recent decision by the Minister of Labor federally to issue a directive to send the dispute between the railways and their 9,000 unionized employees to binding arbitration without a back to work vote in Parliament. So, Ryan, this directive from the minister sending it to binding arbitration, are there any guardrails? This was part of the legislation, the governing legislation, but are there any guardrails on when that type of directive can be issued, or is it pure discretion, or are there certain limits?
Yeah, so I think it might help to look a little bit at the history. Just before the break, you were mentioning that it hasn't been used very often. That's right. Back to work legislation has been used about 170 times since 1950s. That's what we're used to. This one, we don't have a lot of precedents. I understand that in about 2012, conservative government, 2011 with an airline, it was the sales and service people were out on a strike. It was used at a time when the parliament wasn't sitting, so they couldn't do the typical back to work, and they implemented this section 107, which Stephen was talking about earlier, under the Canada Labor Code. There were some challenges at that time. This was before the Saskatchewan Federation of Labor case. These those instructions from the federal government at that time, they were all struck down. Some of them were they imposed that no strikes could happen. It was the Canada Post appeal at that time, plus it was related to Air Canada. So we don't have a lot of precedents on how this would play out. But there are the traditional guardrails in that you have to interpret the legislation correctly. Stephen referred to it earlier. And you also have to be constitutional. I understand that's what the appeals are. And the Constitution is you have to use this with reasonable limits, and it has to be reasonably justified.
Stephen, anything you want to add there? And one of the things I'm thinking about is when Parliament votes on something like back to work legislation, it's perceived by the public as a part of the democratic accountability. And there can be political consequences to having Parliament vote on something like this. And this sort of gets around that accountability, that democratic accountability. It kind of evades some of the political repercussions that every member of Parliament might bear if they were to vote on it. So, what do you make of that?
It's a great question because return to work legislation in this case for the rails would have failed. The Liberals, if the Liberals had tabled the back to work legislation in Parliament rather than doing it this sideways method under the Canada Labor Code, they would have had the NDP and the Conservatives for sure voting against it. And likely the bloc as well with the strong union support that you have in Quebec. So if that turned into a confidence motion, that could even topple the government. So by doing it the way they did, they evaded the application of Parliament and the democratic process that you're talking about. So it's a sideways method of doing it, and they even asked one of the former conservative labor ministers about this, and she said, I wouldn't have been able to get a legal opinion saying I could do this. Um, so I look at this, and it's going to be interesting to watch it being challenged in court because, as Ryan said, the application of the charter in this case, and our Supreme Court has said that the charter protects two things: the right to bargain collectively, that procedural right to sit at a table and bargain, and the right to strike. But the limit on the right to strike is if you have an alternate method. So the SFL case that Ryan was talking about is one where the government of Saskatchewan had declared things to be essential services, but they didn't have binding arbitration. They
Mhm.
didn't have a method. The the employer, in that case, one of the health authorities, could declare you to be essential, and then you just had to accept it. So what the Supreme Court said on the right to strike is you need to have this balance. You need to have a method to resolve the disputes. And in this case, we've got the binding arbitration that they've used. So when this goes to the Federal Court of Appeal, it's going to be very interesting to see what the Federal Court of Appeal makes of it in light of what the Supreme Court has said. Because if
Ryan,
we go back, oh, sorry, go ahead.
Yeah, I just anything you want to add to that, Ryan? We've only got about 20 seconds.
Yeah.
No, I agree with Stephen. I think that I think it's more likely not to be upheld for the reasons that
Hmm.
Stephen said, that there is a meaningful process.
Right.
I don't know
We,
if Stephen would agree with me, but I think that that's maybe what's
right.
going to happen in
We've
this
we've
appeal.
got to go to break, but we'll be right back.